Social Security, Management and International Finances, Part 2. Social Security is a system implemented to provide the natural public by guaranteeing for the natural public for the protection through economic risk redistribution when situations of need arise. The Social Security system in Spain, besides being a universal right of all citizens, includes special protection for workers and the risks that they are exposed to at work, especially those imposed by unemployment. The management and administration of Social Security in Spain rests on the diverse network of government agencies. The principal agency tasked with this management is, even as such, Ministry of Labor and Social Affairs, which is chaired by the Secretary of the State of Social Security and depends on the following governmental bodies: the General Management and Planning of Social Security, the General Intervention of Social Security, let's look a few more here, the Legal Services of Social Security. Those three. The agencies and entities that operate under the auspices of the Secretary of State are the National Institute of Social Security, the Social Institute of Marine Affairs, General Treasury of Social Security, the IT Management of Social Security, and the Public Service of State Employment. Here are the laws governing them. Now let's look back and have a little bit of a description of each of those organizations. General Management is in charge of the functions and development of legal and financial aspects of Social Security, namely the planning and implementation of legal, economic, financial, and demographic studies, drafting budgets, and monitoring the economic budgets of the management bodies and common services. The Intervention, Social Security is the body that controls internal affairs and is charged with management and operations of the financing accounting. Kind of like a watchdog. The Legal Services is in charge of carrying out functions related to the legal counseling and both representation and defense in trials of managing bodies and common services. Now comes the agencies that operate under this auspices. The National Institute of Social Security is the job to manage and administrate the economic benefits of Social Security, excluding those corresponding to the autonomous communities of Spain. The Social Institute of Marine Affairs is responsible for the social security of the maritime and aquaculture sectors and realization of the special regime of Social Security for those who work in the aquaculture sector. The General Treasury of the Social Security, its functions is the management of financial resources and the financial administration, applying to the principles of financial solidarity. Essentially, it is the proprietor and manager of all SS assets. And then, of course, we have the IT management of Social Security. Its task is related to the use and application of new information and communications technologies. And the Public Service is responsible for the management and control of unemployment benefits, the analysis of the labor market, the public register of employment offers, as well as the policies of training and placement of employees transferring to the autonomous community. The laws governing Social Security are these: general laws, royal decrees. Maybe it's worth reading. Okay. One of the decrees is concerning the registration of companies, their affiliation, leaves of absence, and variations of data. Another is approving the general collections regulations. Third is the approving of the general regulations on trading and settlement of other rights. And yet another, modifying the general regulations in regard to the registration of companies' membership, workers' leave, variations of data in relationship to workers' protected, collections of, mutual insurance of the occupational hazards and workplace hazards. Registrations and insurances. As was mentioned in the beginning of the third block, any company prior to hiring workers must be registered in the General Treasury of Social Security. And thus, once a company has been registered and already has their identification listing, they may proceed with the hiring process. When examining the process of registration and insurance of workers, the following should be taken into account. Membership and registration of the workers. The membership in the administration procedure by which the General Treasury of Social Security registers and includes a person in the system. This process encompasses the following: mandatory for all those starting professional activity, is constant and unchanging throughout society. As to say, workers only need to join once, and that membership is maintained regardless of change in working systems or activities. It is a lifetime membership and continues even after worker has been terminated. It is exclusive to the social security system, and the worker cannot be registered in other social benefits. It grants the worker certain rights as well as posing obligations. Membership of a worker can be undertaken in three ways. At the request of the employer, all employers are obligated to register all employees that are not yet registered. If the employer fails to fulfill this obligation, it is not only considered a serious offense, but it has implications for corporate responsibility and benefits. You can also register at the request of the worker themselves. When they are self-employed, the obligation for them to register rests on their shoulders, and they must do so prior to starting work. Furthermore, when the company neglects its obligation to enroll its workers, those workers can apply for registration directly by request of the General Treasury. If the General Treasury has evidence that this obligation has not been fulfilled, they will obligate registration. Now, the following information is required when registering: the address of the company, the establishment where the self-employed individual will work, or failing that, his or her home. In the case of workers included in the special regimen of the Social Security for marine workers, their registration should be submitted to the provincial or local Social Institute of Marine Affairs. You can apply at any of the offices of the General Treasury of Social Security, or those registry offices, post offices, governmental offices, general state of autonomous communities, diplomatic representatives, or consuls of Spain abroad. It's imperative that this registration is made long before starting the employment contract. Once the registration is done, the Provincial Directorate of the General Treasury of Social Security issues a Social Security card containing identification data and registration numbers of the applicant. And as mentioned, this number is lifelong. Information in regard to the registration of foreign workers is outlined in the Royal Decree. The procedure is the same for foreign workers as for nationals, providing that the foreigners are legally residing in the country and have received prior authorization to work in Spain. The data for both employer and employee is submitted to the General Treasury and is subject to occasional change due to personal or work circumstances. Variations should be reported to the Treasury within 3 calendar days for any modification of data concerning the company or worker, whether employees or self-employed. Termination of workers refers to the administrative actions taken to end the employment relationship between the workers and the company and subsequently dissolve the legality of Social Security. It is the responsibility of the employer to notify the Social Security General Treasury of the termination within 3 days. It's important to note that if all the proper steps of termination are taken, the obligation to contribute to Social Security ceases. However, in cases where the dismissal is not notified within the allotted time, the obligation to contribute continues until the General Treasury is notified. With that being said, the workers can choose to demonstrate the actual date of termination in a legally valid manner so that they have no longer the obligation to contribute. Now we come to the cessation of business activity. In the case wherein aspects of the business permanently cease to function, the Treasury must be notified within 3 calendar days following the termination. They must also attach information about the manner in which downsizing or secession will affect employees. In the case where the company has not registered anyone for a period of over a year, Social Security will suspend their active status until a new employee is registered. Training contracts. The following sections will discuss a specific classification of contract called training contract. When the company desires to register an employee by means of training contract, it is imperative that the employer has previously obtained a second code for the Social Security contribution account. Once this account has been obtained, the employer may release this employee from his current contract and have them start their training contract. It is important to note that not all employees are eligible for training contract, as long as they meet the following requirements. Workers for training contracts must be over 16 and under 21, with the exception of disabled people. These workers should lack professional qualifications or certifications required to formalize a regular contract for the desired work activity, and when a contract is granted to the unemployed student workers for public employment training purposes, the maximum age is set out in the regulatory content of those programs. Worker membership and registration in the special regime of self-employment. Self-employment refers to workers over 18 who personally perform or undertake economic activity for profit without being subject to a contract drafted by other persons. The application process for self-employed membership should be submitted to the General Treasury in the place or province where the worker performs his or her professional activities. It is important that the membership is requested before the start of the work activity. Additionally, it is worth mentioning that it is possible to be registered through another regime and to simultaneously perform multiple services. The Provincial Directorate of Treasury or similar administrative bodies are notified of the process of registration for self-employment within 30 days of having started the work activity. The worker is obligated to contribute from the day of his or her registration, whereupon they become eligible for the many Social Security benefits in the special regime of self-employment. France, RETA. Those who are tardy with the registration will only receive the benefits of RETA at the beginning of the calendar month after they have organized and submitted all of the necessary paperwork. Here is an example of RETA, a Régime Spécial de Travailleurs Autonomes. Oh, this is the autonomous regimes that we were talking about before. The special regime for self-employed workers. As the name suggests, it is a special social security regime that applies to people who are self-employed and is part of the general Spanish tax system. Here is some details of what that might be. Self-employed workers over the age of 18, the spouse or first and second degree relative who collaborated with the self-employed workers but are not employees, self-employed workers who rely on one client, foreign self-employed workers residing and working in Spain, members of cooperatives, civil societies or individuals, co-owners that hold communal property, self-employed workers who need to be members of a professional association due to the nature of the work, and directors or administrators of commercial companies if they hold 50% or more of the capital shares. There are some of the qualifications they must have. During the registration of a self-employed worker, they must choose whether or not to cover periods of temporary disability, and if so, it should be managed by a mutual insurance policy. The payment to Social Security are administered on a monthly basis. The contribution for the self-employed worker is calculated using a minimum and maximum contribution base, and the contribution base is based for 2018 based on these numbers. Anything between 919, 80 euros and 3,751 euros. We're not going to go into details in regard to self-employment workers and the contributions. However, in the annex, there is a link that examines the base and contribution rates for different types of workers. And when a self-employed worker wants to unsubscribe, they should notify the agency of their intent at least 6 days prior to their registration. And if they fail to do so, they must continue to pay. During the time that they are registered with Social Security, they must pay monthly installments. Depending on the contribution rate corresponding to each worker, not including any form of bonus, the amount will be applied in a series of percentages that will thus be to determine how much each self-employed worker owes in monthly dues. These percentages are set out by Social Security and are different depending on what benefits are contributed towards, and they can include these things. Common contingencies is 29.8%, and professional contingencies, plus the amount decided on CA, which typically ranges between an extra 1.5 and 6%. Termination of activities, 31.5% of base. In 2018, the minimum fee is €275. It is important to note that those who register as self-employed for the first time receive a lower fee. This abbreviated fee is €50 per month, and as of this year, will be paid during the entire year of the employment. As mentioned, these fees are paid monthly via the financial institution and are addressed to the tax management and general treasury of Social Security. And these fees are not paid before the deadline of surcharge, and interest will be charged and accumulated respectively. And surcharge is 20% is the amount due to payment is made later than the deadline. The interest will start to accrue the day after the deadline and will be enforceable after 15 days of not paying the overdue debt. For further information regarding self-employment, refer to the annex where you will find documents for the outline of various aspects for fee calculation to contingency protection. Now we have a special system for domestic employees. This refers to workers that provide and are paid for domestic services for the head or heads of household, provided that such services are undertaken in that specific domicile. This includes jobs such as childcare, gardening, driving, person transportation. Inclusion of workers in this special system is contingent on both hours worked and number of employees or employers. Thus, the distinction is made between regular home employees, those who provide services for a single homeowner for a total working time equal to or greater than 80 hours a month, and the intermittent home employees, those who provide services of either one or multiple homeowners in a part-time manner for a total minimum working time of 72 hours per month and for at least 12 days a month. With the approval of the Royal Decree, a number of changes were made to improve the management and social protection in the special system for domestic employees. Those workers included the special system of domestic employees who work for less than 60 hours a week per week. Per week? Okay. Should register, unregister, and make data changes only when agreed upon by their employer. Similarly, the aforementioned requests and changes must be signed by the employer. Social Security benefits. Benefits are sets of measures to enable Social Security to anticipate, address, and overcome situations of misfortune, specific needs, or disabilities which often result in a loss of income or general financial insecurity on the part of the sufferers. The benefits are grouped in four types: pensions, subsidies, compensation, other benefits. Pensions. These economic benefits are accrued daily over the lifelong duration or until a specific retirement age. Subsidies are benefits accrued periodically and/or in a temporary manner. Compensation are benefits that are paid on a one-off basis. And other benefits include unemployment benefits and other family or personal protectionary measures that are not economic. In addition to these economic benefits, it is important to mention other in-kind benefits such as healthcare, pharmaceutical care, and social services. Let us take a look at the universal truths of Social Security. They are benefits to the public. They are non-transferable and inalienable because beneficiaries cannot sell their rights to them, pass them on, or give them up, except for occasional options once granted in the case of inconsistency or incompatibility of benefits. The benefits are protected from third parties, that is to say, they are not subject to withholding, compensation, or discounts except in pre-established cases: child support, incurred individual social security debt, etc. They could only be seized in terms of the amount set out by the law of civil procedures for pensions and salary earnings. They are preferential charges and are general privilege credits. They have specific taxation because they are subject to taxation under the terms established in the regular standard of each tax. Let us take a look at the benefits of Social Security. Healthcare. General health care aims at providing medical and pharmaceutical services to beneficiaries in need so as to restore their health and ability to work. It also provides access to medical services that see to the result-based healing process, namely physical rehabilitation, so as to assist the worker in his or her successful recovery. All workers who are registered contributors to Social Security are entitled to these benefits. In addition, there are other persons, usually family members, who are entitled to some of these benefits by proxy of the relationship to the contributor, as long as they are not eligible by alternate means. Medical care is dispensed in the form of outpatient, inpatient home care, as well as other special circumstances. Pharmaceutical benefits are also taken into account. Now let us look at some of these. Temporary disability. This benefit refers to the daily allowance provided for the cover of the loss of workers' daily income due to the following: a common illness, a non-working accident, occupational sickness, workplace accident, etc. In these cases, those registered with Social Security can benefit from these provisions. To receive Social Security benefits for a common illness or a non-workplace accident, the beneficiary must have contributed for at least 180 days in the past 5 years prior to the sickness. However, for occupational sickness and workplace accident, a previous contribution period is not necessary at all. The amount of benefits provided for is as follows. Common illness or non-workplace accident, 60% of the base between the 4th and 20th day, 75% from the 21st day. Occupational sickness or workplace accident, 75% of the base starting the very day after discharge. Payment is granted by the entity that recognizes the right to entitlement, either the mutual insurance company or the Social Security. It can take the form of delegated payment and be carried out by the employer on the monthly payroll of the worker, or deducted from the contribution payments. For a common sickness or a non-workplace accident, the payment runs without deduction between the 4th and 15th day. However, it can sometimes be direct payment, in which case the worker will be compensated directly. The worker will be paid in the following cases: when the work relationship is finished and the worker is still in the case of IT, when companies with less than 10 employees have been paying the allowance for longer than 10 months, when the worker claims non-compliance on the part of the employer to the taxation entity. The subsidy lasts for a maximum of 12 months with a possible 6-month extension if it is presumed that the employee can recover. When calculating the time period, relapse should be taken into account, as should the potential for a lessened labor activity in the first 6 months after returning to work. After 18 months, the employee will be proclaimed cured, or if still unable to work, the worker will be transferred to permanent disability. Maternity. This allowance is granted to workers during the legally established period of rest following childbirth, adoption, foster care, or guardianship, with each case having different requisites, and allowances. Beneficiaries who were considered fit to work or in a similar situation are entitled to benefits if they meet the following minimum contribution requirements. No minimum period for those who are under 21. This is for maternity. 90 days in the past 7 years, or 180 days in all their working life, or works between 21 and 26. 180 days in the last 7 years. Yes, 180 days in the last 7 years in all their working life for those who are 26 years. Yeah. What this is there is, it's in order to get maternity benefits. You have to have at least 90 days in the last 7 years, 180 days in all your life if you're less than 26, but more than 21. Here, you have to at least 180 or even 360 in all your working life for those who are over 26. Okay. Even if a worker does not meet the minimum requirements, a subsidy of 100% of the public income index will be paid. The payment will be made directly by the INSS worker at the request of the worker. The duration of the allowance is as follows. This is about pregnancy, maternity. 16 weeks with a 2-week extension for each child after the second child. Multiple births or adoptions, and 2 weeks of disability. For premature childbirth, or if the newborn is hospitalized for more than 7 days, the allotted hospitalization is increased up to a maximum of 13 more weeks. When the mother does not meet the minimum contribution requirements, the duration of the allowance is 42 days. In the case of multiple births, a single parent family, extended family, or when the mother or child are affected by a disability equal to or greater than 65%, the allowance will be increased by 14 days. Paternity. These benefits are granted to workers who suspend their employment contract or cease working activities during legally established days of following the birth of a child, adoption, or foster care. And the beneficiaries of the allowance are, in the case of childbirth, the post-birth leave allowance is exclusively offered to the other parent. In the event of adoption or foster care, it is up to one parent to choose to receive the benefit, except when one of them has already received a full paternity leave, in which case the paternity allowance is recognized in favor of the other parents. To this end, the beneficiary must prove at least 180 days of contributions in the last 7 years, or 360 throughout their working life. The amount of paternity allowance is 100% of the base, which will be paid directly to the worker after it is solicited from the INSS. Risk during pregnancy. The purpose of this provision is to subsidize the loss of income that occurs when the worker's employment contract is suspended due to the high-risk pregnancy. This is especially important in cases where women have changed their job to one that is more compatible with their pregnancy, and such a change is not technically feasible or deemed unreasonable for other reasons. All those registered in Social Security are beneficiaries of this allowance, regardless of the contributions or lack thereof. Both risk during pregnancy and risk during breastfeeding allow for the suspension of the employment contract without termination. The amount of this allowance is 100% of the regulatory base, as established by professional contingency, and upon payment, the amounts are deducted from Social Security contributions and withholdings or income tax. This benefit takes effect simultaneously with the suspension of the contract and is payable for the necessary period as directed by the doctor. As for its completion, it is given a day prior to the start of the suspension or when the worker restarts their work. The management and payment is undertaken by the Social Security or the mutual insurance company, depending on which is charged with providing coverage for those professional risks. Risk during breastfeeding. The purpose of these contributions is to provide a safeguard for those women who are identified as being at risk during breastfeeding until the child is at least 9 months old. Sometimes this can result from further suspension or a job change when a certain work activity is identified as presenting a risk to the child or proven unreasonable for other reasons. Similarly to before, beneficiaries are any person registered, regardless of their contribution history. The amount of the allowance is 100% face value upon payment. The amounts are deducted from Social Security and income tax withholding. Benefits will be paid as long as considered necessary for the protection and safety of the worker and the child until they are deemed ready to rejoin their job. And it will be ended when the child reaches 9 months of age, when they return to their previous employment or another job compatible with the staff, on termination of the employment contract for legal reasons due to interruption of breastfeeding or death. Self-employment, when their child reaches 9 months, when they return to the professional activity by registering in the special regime, or death. The management payment is undertaken by Social Security or mutual insurance company, depending on which is responsible for providing coverage for this occupational hazard. Partial permanent disability, IP. Partial personal permanent diabetes is governed by a royal legislative decree, and partial permanent disability refers to a disability that incapacitates the worker by no less than 33% of his previous work capacity without rendering them fully disabled after their withdrawal from work and prescribed medical treatment. And it can be viewed in 4 distinct degrees. Partial disability that affects normal professional development, total disability that affects normal activities, absolute inability to work in any profession or trade, and severe disability. The beneficiaries of this allowance are registered members who are discharged or on leave, those whose disability is directly a result of a work accident or an occupational sickness. In these work-related cases, they are considered full members and entitled to leaves of absence even if the employer has failed to fulfill their obligations. In cases where the disability is a result of an accident, there is no required previous period of contribution. Some exceptions to this are the 1,800 days of contribution made in the 10 years prior immediately to the start of the temporary disability. In order for workers with part-time contracts to meet the required contribution period, the rules established by this royal decree. The benefit is granted as a lump sum allowance. The amount is equivalent to 24 monthly payments on a base level, which serve to calculate the subsidy of the IP derived out of the permanent disability. It is important to note that this allowance is given to employees and self-employed workers alike. To opt for this benefit, you must first assess the worker's disability and assess whether they meet the aforementioned requirements. Once the IP has been deemed as admissible by the governing panel, the management is passed on to Social Security or the mutual insurance company along with application forms, a photocopy of the identification, certification of the company, and family register. Payments are carried out by direct payment through the National Institute of Social Security. If the IP is a result of a common illness or non-workplace accident, the National Institute of Social Security or the Mutual Workplace Accidents and Professional Illnesses of the Social Security, when the disability derives from a professional illness, National Institute of Social Security or the Mutual Accidents Work and Professional Illness of Social Security, where the disability is derived as a workplace accident. Now we come to permanent disability. This benefit is recognized by the workers who have already gone through treatments and have been deemed fit for work, and yet still have a number of ailments or illnesses related to that problem that affect the capacity to work. Beneficiaries must meet the following requirements. Worker must be registered and be fit to work or in a similar situation. If the disability is the result of an accident, no prior contribution is necessary. If the disability is a result of a common illness, under 30 years old, having contributed a third of the time between the date and he or she turned 16, and the outset of the accident thus resulted is in the aforementioned disability benefit. Or 31 years or older, having contributed a quarter of the time between the dates he or she turned 20, and the outset of the accident thus resulted in the aforementioned disability benefit, with a minimum of 5 years. A portion of this period must be within the last 10 years. The amount of compensation is determined by applying 55% of the regulatory basis and adding 20% after the age of 55. The age at which it is presumed difficult to find new employment. In certain situations, the case can be made that the pension can be substituted for a lump sum contribution. Thus, this must be managed within 3 years while the worker is still under 60 years old and is still working, and that there is no modification of his or her degree of disability. The allowance takes the form of 84 monthly payments. That's 7 years, by the way, when the worker is under 54, down to 72 monthly payments. That would be 12 years. No, not 12 years, it'd be silly. 6 years. When he or she is over 54 and is lessening to monthly payments lessening to 12 monthly payments when he is 59. The benefit is compatible with any job, excluding the performance of the same position within the company. In the case that a worker is performing another activity that makes him or her susceptible to further inclusion in one of the SS programs, they are obligated to be fit to work and pay and must report the situation to the appropriate governmental bodies. If the worker is deemed permanently disabled, they qualify for 20% added to the 50% of the regulatory base, only as long as they do not do any work which would disqualify them. Absolute permanent disability. This type of disability is where the worker is completely and utterly unfit to undertake any profession, trade, or work of any sort. The beneficiary of this disability must be registered and be considered fit to work or in a similar situation. However, in this case, where the employers have not registered their employees as fit to work, these workers are still entitled to the benefit. If the permanent disability is caused by a common illness, the prior period of payment must be at least 100 or 1,800 days made in the last 10 years, immediately before the start of the temporary disability that the IP is derived from. In order for workers with part-time contracts to meet the required period, the rules are established by the royal decree. If the disability is a result of a common illness or a non-workplace accident and the worker in question is unfit to work, it is necessary that they have to make the following statement, stipulations. A generic statement of a period of 15 years, a specific period of 3 years of payment within the last 10 years. In case where the disability results from workplace accident or professional illness, a prior period of Social Security contribution is not needed. The amount of the benefit is 100% of the regulatory base, although in the case of AT or EP, pensions will be increased according to the gravity of this injury, starting at 30% and potentially reaching 50%. Reception of this benefit does not inhibit the individual's ability to undertake activities, whether for profit or not, as long as they are compatible with the disability and do not represent a change in their ability to work for revision purposes. In the event that the recipient of these benefits begins work, they must be reported immediately so as to properly internalize any potential revisions to the degree of disability. The general management of these services is undertaken by the INSS. Payment overseen by, in cases where the IP is caused by a common illness or non-working related accident, payment is made by the INSS. In the case of professional illness or workplace accident, payment can be made either by INSS or a mutual insurance company. Then we come to severe disabilities. This is a situation where the worker is incapacitated permanently and due to having lost motor control or other functions requires the assistance of another person to undertake day-to-day activities such as eating. The requirements in order to receive these payments are the same as absolute permanent disability. Beneficiaries of this disability must be registered and be considered fit for work or in a similar situation. However, in cases where the employers have not registered their employees as fit to work, these workers are still entitled to the benefit. If the permanent disability is caused by a common illness, the prior period of payment must be at least 1,800 days, or in order for work of part-time to meet the requirement, the rules are established by the Royal Decree. If the disability is resulting from a common illness or a non-workplace accident, the worker in question is unfit to work, it is necessary that they have met the following stipulations: a generic payment period of 15 years, a specific period of 3 years in the last 10. In cases where the disability results from the workplace accident, professional illness, a prior period is unnecessary. The amount of pension benefits that are provided for severe disability are the same as permanent, total, or absolute disability, with the supplemental stipend to pay the persons needed to care for the beneficiary. The carer, as we would say in England. This supplement is calculated by adding 45% of the minimum payment base and 30% of the last pay's salary employment. It cannot be less than 45% of the pension without including the aforementioned supplement. The reception of this benefit does not inhibit the individual's ability to undertake activities, whether for profit or not, as long as they are compatible with the disability and do not represent a change in their ability to work or revision purposes. However, it is worth mentioning that as of January 1st, 2014, receiving a pension for absolute permanent disability and severe disability from retirement age will be incompatible with work performance either as an employee or self-employed. Mod 2, Part 2, Non-Disabling Permanent Injuries. This benefit is given as a lump sum to individuals who suffer work-related accidents, illnesses, mutilations, or deformities that lead to the decreased physical state of the worker but is not permanently disabled. This physical ailment or deformity must be able to be quantified on a scale established for this very purpose. Entitled beneficiaries are registered workers from protected professional contingencies and meet the following requirements: have been deemed fit to work or are in a similar situation, have been discharged following a medical process. The injury or mutilation in question is contained on a scale used for assessment. It's important to note that this benefit is incompatible with other economic benefits offered as a result of the same circumstance. On the contrary, it is compatible with work even in the same company. The benefit is given in the form of a single economic transaction or payoff and is reflection of the gravity of the injury or mutilation suffered by the worker. This payment is managed by the mutual insurance company of workplace accidents and illnesses of Social Security. The benefit offered by retirement are now we come to retirement. The benefits offered by retirement are a lifelong pension, which is granted to the workers when, because of their age, they cease to work. In order to receive this benefit, it is important that the workers in question meet the following criteria: they have at least paid into it for 15 years, 2 of which must be in the years immediately preceding the retirement, ceasing labor services now, and the age, retirement age from the year forward to the question is 67 years old and 65 while having paid for 38 years and 6 months. Yeah, it's moved just recently. Anyway, this requisite will be enforceable in any case when the worker has reached pension age without being fit to work or having been unable to work for some time. Retirement age and contribution periods, as have been referred to in the previous paragraphs, shall be applied gradually as explained in the following graph. Yeah, they were jacking it up from 65 years to, very much so. Very straightforward. They're jacking it up. Oh boy, oh boy. Here comes now 66. And I think you're gonna pop it right up to 67, maybe. Oh yeah, there she is. Wow. Yeah. Exception. The age of 65 is maintained for those who have the right to apply the legislation prior to this special date. In accordance with what is provided for the fourth transitory provisions of LGSS, the minimum age can only be reduced in the following special circumstances: anticipated retirement after 60 as members of an insurance company, anticipated retirement after 61 years without the agreement of the members of the insurance company, Partial retirement, special retirement at 64 for those who receive grandfathered legislation prior to this magic date. Retirement for minors is provided for the mining statute, flight personnel, train workers, artists, professional bullfighters. Very interesting. Firefighters and police officers. But not paramedics. Flexible retirement. Retirement workers affected by the disability greater than or equal to 45 to 65%, depending on the severity of the disability. Isn't that interesting? Wow. No case can a worker qualify for retirement if she's under 52. Yeah, let's just pause. As you can see, here are some of the exceptions that allow you to retire early from Social Security net. It is important to note that in no case can a worker qualify for retirement if she or she is under 52, and the exception being coal miners, fishermen, who are recognized as potential candidates for early retirement. Now, retirement can be distinguished as one of the variety of types depending on the variables. Here are the variables. According to the contribution period, contributory, included with the general program and the special program of Social Security, these carry minimum contribution requirements. Non-contributory, these specifically for students who are found in situations of need, but these are no need for a contribution history, and even if there is, they do not need to reach the otherwise needed contributory minimums. Depending on availability, the total, the worker complies with all applicable requirements for drawing the retirement pension, the worker completely ceases their work activities, or partial. This presents the possibility to combine a Social Security pension along with part-time work, and the requirements for access are, in the minimum age in each case is a result of the application, with or without a relief contract. They are able to work part-time and sign on a contract as such. The reduction in the working day is between 25 and 75%. The minimum contribution period corresponds to the contributory pension. Seniority in the company is not necessary. No relief contract is required. Under 65, with a relief contract, they must have a full-time work day contract. If they do not have a union-sponsored job, they must be at least 60 years old. If they are accredited with 6 years of seniority in the company and 30 years of contributions, they will be able to undertake part-time retirement after 60 years old, with a maximum reduction of 85% of the workday. The relief worker must be contracted as a full-time worker indefinitely. Workday reduction between 25 and 75% and up to 85% in certain cases. The limit of the maximum reduction is applied gradually. Minimum of 30 years contributions not taking into account proportional amounts of extra payments and bonuses, and at least 6 years of seniority in the company prior to the part-time retirement. Now we come to early retirement. By reason of professional group or activity, the retirement age can be earlier when work activities are physically demanding, toxic, dangerous, or unhealthy. The worker must be in a situation where they are fit to work, or in a similar situation and must meet all the other requirements. Due to disability, for employees affected with the disability greater than or equal to 65% or 45%, or if the disabilities determine a reduction of life expectancy of the person, the age can be lowered to 65. By having union status, citizens older than 60 who are fit to work and have met aforementioned requirements such as a contribution minimums and time minimums, contributors on behalf of some labor unions, those belonging to the Spanish Narrow Gauge Railway Company and other state railway workers, those who fall under the scope of a special program for coal mining established in 1969 and who were contributors to the coal union, those belonging to the special group of sea workers on or prior to 1970. Now, if you're non-union, you must be 61 years old, have a minimum contribution of 30 years, including military or alternate service with a limit of 1 year, excluding the share of extra payments or contributions prior to 1967. At least 2 years of the above-mentioned contribution will have taken place within the 15 years prior to the end of the obligation to contribute, while also deemed fit to work. Flexible. This possibility of reconciling one person's pension with a part-time contract results in the reduction of the inverse of the application reduction to the workday of the pensioner in comparison to that of the full-time worker. When examining different types of retirement, it is important to note that the pension not only ceases with the death of the pensioner. That is to say, the pension can be suspended by assumption or by reincorporation into work, but it can never fully cease. The retirement pension amount is determined by the application of the regulatory base to the percentage as determined by the contribution time. In those cases where the retirement is delayed, a bonus of 2 to 4% per year of the delay can be accrued. It is payable in 12 monthly installments along with 2 bonus payments in June and November. For early retirement, the pension is reduced by 8% per year or fraction of the year thereof, but the citizen does not meet the minimum age requirements. Pension is both requested and processed by the provincial addresses in the NSSS. In order to file a request, one needs to file the official form using their tax ID number along with proof of contributions and family register. The same provincial INSS will process and pay the retirement pension. Now we come to the death grants. The requirements to take the form of economic assistance to help offset the funeral costs paid by family members. The recipients can be the spouse, the surviving partner, the children of the deceased, family members who have lived with the deceased. If another person has paid for the funeral, reimbursement for their expenses can be requested. No previous contribution period is required, and the funeral can take place up to 5 years after the death. Reimbursement is solicited from the INSS by filing the official forms and providing identity card, death certificate, marriage certificate, and/or proof of expenses. The resolution period is approximately 13 days. Widow's pension. This is a lifelong pension granted to those who were married to or had a domestic partnership with the deceased, provided they meet the requirements. In the case of death by common illness, to qualify for this benefit, it is important that the deceased was fit for employment and contributed to the Social Security for at least 500 days within the 5 years prior to his or her death. In the case of death caused by professional sickness or an accident, either work-related or not, no prior contribution period is required. As explained above, the beneficiaries are the spouse or domestic partners of the deceased, as long as they have not remarried. These include the spouses who have already separated, divorced, or persons whose marriage was annulled, legal partners at the time of death. The amount received is calculated by applying 52% of the regulatory base and varies based on the employment status of the deceased at the time of death, as well as the cause of death. It rises to 70% if the widow or widower has dependents, children under 26 years old, or those who are older and have a disability of 33% or more who live with them, and can reach up to 75% if the benefit is considered the main source of income. The widow's pension is compatible with salaries of the recipient and also with the pensions granted for disability or retirement benefits. However, the person loses their eligibility in the following circumstances: remarriage or a new domestic partnership with exceptions, following a declaration of guilt for the final judgment of the cause of death, or gender-based violence, for death by proving that the mission worker is not in fact deceased. Orphan's pension. This is an economic benefit granted to the children of deceased and those spouses, provided they meet the following requirements. The children of the deceased are under 18 years old and are affected by some disability. Offspring under 22 years old, or 24 if they have no surviving parents. When they are unemployed or their salaries do not exceed 75% of the average wage, the children of the surviving spouse, if they live together with the deceased for 2 years prior to the death, those born after their death. The amount of the benefit is 20% of the regulatory base of each orphan of the deceased, increasing to 52% in the addition to the widow's pension if there is no surviving spouse. In the case that there are several beneficiaries, the sum total of both pensions, widow and orphan, may not exceed 100% of the base. The orphan's pension is compatible with any other employment income, be it that of the spouse or the orphan, similar to the widow's pension. If the orphan is older than 18 years old or has reduced capacity to work, the benefit is compatible with any of his or her incomes for working out. For orphans older than 18 that are employed, the pension cannot exceed 75% of the SMI, or the orphan's pension is suspended for the duration of their employment and resumed at the end of it. Like in the case of the above benefits, one must be requested by the INSS, and this pension, which is payable on a monthly basis with 2 bonus payments with due in November, except for the case of professional illness or workplace accident, in which case the bonuses are spread through the monthly payments. When the orphan is under 18, the pension shall be paid to their legal guardian, who will be paid directly to them when they turn 18. The cessation of this pension will occur for the following reasons: for those older than the maximum age, except in the case of disabled persons, by ceasing of their disability that grants entitlement to the pension, by adoption, by marriage, with some exceptions, by death, by proving that the missing worker is not in fact dead. Unemployment benefits. The objective of this benefit is to protect individuals who are able and willing to work but lose their job temporarily or experience a temporary 10 to 70% reduction of their workday. It is essential to have a past history of contributing to Social Security in order to receive this benefit. The Public State Employment Office is the independent body responsible for the management of these benefits. In addition to having contributed to Social Security previously, the other requirements are being fit to work, registered in a program that takes into account unemployment, being legally unemployed, being able to prove the employment is actively being sought, being willing to accept an appropriate work placement and sign an employment commitment, having contributed for a minimum of 360 days within the last 6 years before unemployment and at the end of the obligation to contribute, not having reached the required age for receiving a retirement benefit. In order to benefit from unemployment, aside from meeting the above-mentioned requirements, it's important that the person in question does not fall into any of the following incompatible circumstances: employed workers, including the general program of Social Security that pay for unemployed contingencies; employed workers, including the special programs that safeguard unemployment contingency, such as coal miners, seed workers, employed by the special program, and their names like permanent agrarian workers, employed by the special agrarian system; those whose members of the work cooperative and agricultural cooperatives, also known as members of a cooperative, that are included in the other programs that protect this contingency; prisoners who have been released or are serving parole; retired returning migrant workers; foreigners that are not part of the EU, or those who are not legally residing or working in Spain. Employment officials and staff temporarily hired by public administration positions, supplemental military soldiers and professional troops and Marines; seniors paid public administration employers; senior paid public administration employers who are not public officials and are not entitled to receive any type of compensatory benefit as a result of their termination. Unemployment benefits include partial or total economic benefits in the form of compensation for unemployment, the payment of part of the contribution to Social Security during the period of unemployment. Unemployment benefits are validated in the normal manner of certification by the company, which reports its cause and date, and must be accompanied by the appropriate documentation. Legally recognized causes of unemployment are as follows: dismissal due to objective cause, employer death, employer retirement, employer disability, collective dismissal decisions made by the employer or due to a judicial decision made in a bankruptcy proceeding, temporary reduction in the working day as decided by the employer or due to the judicial decision made in a bankruptcy proceeding, cessation of a trial work period at the behest of the employer, voluntary cessation on behalf of the employer in their employment relationships with senior management, end of temporary contract at the request of the employer, expulsion of a member of the cooperative in accordance with the governing council, workplace transfer or substantial modification of working conditions, and or interruption of permanent seasonal worker activities, completion of a fixed-term corporate bond, completion or involuntary termination of commitment to the armed forces, end of performance with finalization of contract, in the case of audit artists, involuntary termination from public office or unions, termination or suspension of the employment of victims or perpetrators of gender violence, termination for permanent disability declaration together with the necessary documents, termination or temporary suspension or temporary reduction of the workday between a minimum of 10 and a maximum of 70% of the worker members of the cooperatives due to the economic, technological, or force majeure causes, along with the necessary documents required. The duration of this benefit provision shall be established according to the period of occupation paid by the Social Security program that protects this contingency in the 6 years prior to the legal situation of unemployment or in the moment when the contribution ceases to be obligatory. It is important to note that when settling the duration of this provision, only those contributions that have not already been computed for the prior recognized right at computation. In addition, other payments or contributions offered by the public state employment service or the company, except for the case of victims of prior gender violence, will not be computed. To calculate the paid period of occupation, make sure to take into account annual paid vacation leave that was unused prior to the contract's termination. Also take into account salaries that are still being processed. In the case of reduced working hours, the payments that correspond to part-time and full-time work, each workday is counted as one full day paid, regardless of the duration of the day. To apply for this benefit, the worker must be performed the following procedures. Registration as a job seeker and application for benefits of the Office of Public Employment Service. The deadline is within 15 days following legal unemployment. Commitment on the part of the beneficiary to actively seek employment, accept an adequate placement if offered, and undertake action that would assist him or her in finding new employment. Proper placement is considered to be one in the profession of the worker or one that corresponds with his or her normal occupation or another of their aptitudes. However, in the years prior to the receiving the benefit, prior professional notwithstanding, other occupational opportunities deemed appropriate by the legal management entity are also considered. Prior placement is considered to be within 30 kilometers of the worker's in question's habitual residence. This is not the case when the minimum round-trip transit time is more than 25% of the duration of the workday, or if the cost of the transit constitutes more than 20% of the monthly salary. Proper placement involves a equivalent job, regardless of the amount of time received by the worker. The management entity shall consider the professional, personal, and family circumstances of the unemployed person, as well as the transportation implications, aspects of the job, and characteristics of the local labor market. In regard to the benefit, it will be paid monthly and will not be less than 80% of the monthly IPREM, plus 1/6 of the total extra expenses when the employee does not have dependent children. 107% of the monthly out of the total extra paid when the worker has at least one independent child or dependent child. For part-time workers, the maximum and minimum benefit paid are calculated by taking into account the IPREM and the amount of hours worked. The State Public Service will forward the resolution to the applicant's address, which will specify the regulatory base, the payment entity, and the date of payment. Payment will be made monthly in arrears to the bank account of the applicant, except in the extraordinary case where the payment will be made in cash. Some situations result in an ineligibility to receive these benefits. Here they are. Paid full-time work that is included in the Social Security program, but that does not intend to contribute to the contingency of unemployment, self-employment, except where it is an established program to promote employment, paid research activities, or partnerships. Designation of public office, unions, or senior administration officials who are paid with a full-time focus. Economic pensions or benefits from the Social Security, both contributory and non-contributory, except those that are compatible. Any other situation that implicates the right to economic insights of the public character. However, the benefit is compatible with paid part-time work within the indefinite contract that supports part-time entrepreneurs without affecting the amount received in the benefit, either self-employed or contracted full-time work that is established to promote employment compatibility, compensation for termination of the employment contract, partial retirement pensions, and financial benefits from Social Security that would be consistent with the work that this benefit originated from, doing social collaboration work. Benefits for dependent children, appointment of part-time paid positions, public or union positions. Finally, cessation of these benefits are caused by the following: depletion of the duration of the benefit, the worker has moved abroad, the death of the beneficiary, circumstantial changes due to the worker's retirement or permanent disability, performing paid work for a period of time greater than that of 12 months, voluntary renunciation of the right to benefit, repeated minor or serious infractions, serious or very serious offenses that result in the termination of the benefit. Benefits of self-employed cessation of work. This benefit is offered to self-employed persons who have stopped their work activities. An established law of 2010, a specific system is established to protect self-employed workers. The beneficiaries of this allowance are self-employed workers, including the special program for self-employed workers. Self-employed workers include the special program of self-employed farmers that are initiated payments of cessation of work activities starting on January 1st, 2012. Self-employed workers included in the special program of C workers. In all cases, it is necessary to have risk coverage in the case of workplace accident or occupational illness, and also in that cessation of work activity. The requirement that must be met by self-employed workers to access this coverage are to be fit to work or in a similar situation, be covered for risk of the AT and the EP, to have covered the minimum contribution period 12 months for cessation of work activity, be legally considered unemployed, agree to actively seek employment and start regulated work activities again, be unable to receive retirement benefits, be up to date with payments of Social Security contributions. The duration of the benefit is calculated using the age and periods already paid to Social Security by the worker in the 28 months prior to the legal cessation of work activity. And the amount received by the self-employed unemployed worker is 75% of 70% of the base, the maximum 175% if the IPREM, and the medium 80% of the IPREM. Depending on whether the worker has dependent children, the minimum can vary between 107% and 80% of the base. No minimum is applied in the case of workers that have not reached the minimum prior contribution of Social Security. The benefit can be suspended due to sanctions, infringements, resumption of work for a period of 12 months, or for having moved abroad. Grounds for termination of this benefit are end of the benefit period duration, resumption of work within 12 months or more, imposition of sanctions, and other causes listed in the law 2010. Unemployment benefits for unemployed assistance. This is a benefit offered to economically assist with healthcare, family protection, and retirement. Unemployed workers must meet the following criteria. They must be enrolled as active job seekers and not have turned down any suitable employment offers or professional training opportunity, not having a monthly income greater than 75% of the standard, and not including the proportional part of extra payments. Beneficiaries eligible for this benefit are employees who have exhausted unemployment benefits and have family responsibilities, returning migrant workers, those older than 45 years that exhausted unemployment benefits and do not have family responsibilities, those that are older than 55 years, workers who have not completed minimum contribution period to access other benefit, those released from prison and currently on remission or on a detoxification sentence. These unemployed are entitled to 80% of the normal. The duration of the provision will be contingent on the situation of the unemployed. Family allowance for dependent children. This is an economic benefit that is granted to each child dependent of the beneficiary who is under 18 years old or is affected by the disability equal to or greater than 65%, as well as foster children, as long as the established income limit is not exceeded. Family benefit allowance per child or foster child. The benefit is applicable to children who live with or are dependent on beneficiary of unemployment. Coexistence is not considered suspended or terminated in the case of temporary separation due to studies, parental employment, adoption, or foster care, medical treatment, rehabilitation, or other similar cause. Those entitled to the benefits must first meet the following requirements: be a legal resident of Spanish territory, have dependent children or foster children under 18 or affected by a disability of 65% or more, not be entitled to any benefits via similar social protection program, not receive annual income in excess of 11,583 euros and 76 cents. This amount is increased by 15% for each additional child after the second. In the case of a large family, an annual income shall not exceed 17,000 euros. For those cases that include three independent children, increasing to 28,000 for each independent child, starting from the fourth and including the fourth. Those who receive an annual income of any kind that exceeding the amounts mentioned are less than the amount resulting from the multiplication of the assigned benefits per child by the number of dependent children. Benefit of multiple births and adoptions. This is the benefit that compensates family expenses in the case of two or more children via multiple births or adoption. The beneficiaries would be such: parents, adopted parents, foster parents who live together. One or two will be chosen by the common agreement, one of the two. If not, the mother will be the recipient. Parents, adoptive parents, or foster parents who do not live together, the beneficiary will be the parent who has the custody of the child. Non-economic benefits for child care, foster care, and other family care. This benefit grants a period of leave to employed persons so that they can attend to the care of each child, as well as the care of family members within 2 degrees of kinship who, for reasons of age, accident, illness, or disability, cannot care for themselves and do not perform paid work. This allotment, leaves of absence, shall not exceed 3 years and may be taken in intervals. It's very important that the implicated company informs the General Treasury of the Social Security of the leave of absence from the beginning to the end, as well as the period that the job will be reserved for. During the leave of absence, the following effects are possible. Seniority continues to be computed. The worker is entitled to attend professional and vocational training courses. During the first year, the worker has a right to keep his or her job. For more information on Social Security in an international context, refer to the annex, where you will find a number of documents and legislative references to the subject.